Good afternoon. Thank you for joining us for this webinar. I'm your moderator, Renee Goodnow from the New York Small Business Development Center. Today's host is the PACE Small Business Development Center. We are a U.S. Small Business Administration resource partner. Our free services are made possible by funding from the SBA, New York State, and our host campuses. As I mentioned, joining us to lead things off is PACE SBDC Director Andrew Flam. Andrew, I will turn things over to you.
Great. Thanks so much, Renee. Good afternoon, everybody, and welcome and thanks so much for taking the time to join us for this session. Again, my name is Andrew Flam. I'm the Regional Director for the Pace University Small Business Development Center, or SBDC. We're located in Lower Manhattan, and as Renee mentioned, one of 22 centers located throughout the state. And our focus is on providing targeted one-on-one business advisory services. We're all staffed by full-time business advisors helping entrepreneurs and existing small business owners build and grow here in New York. So would love to work with you as you are building and growing your business here. I'll talk a bit about the services that we offer very quickly before introducing my colleague, Jessica Magaldi. So as I said, our work is really focused on one-on-one assistance, whether it's access to financing, developing and building out marketing and sales strategies for your business, looking at procurement opportunities, how to be able to access those, operational issues and challenges you might have, and then clearly over the last nearly 2 years now, kind of being able to look at the wide array of COVID-19 recovery programs and being able to assess what might be a good fit for your business, or things that our business advisors do on a day-in, day-out basis. So if any of those items strike a chord, I will be putting a link in the chat in just a moment where you can learn more about the work that we're doing and a link to ask for a counseling session with the business advisor. All of our sessions and all of the work that we do is offered at no cost. And I said, kind of based on the varying support we get from the federal and state government, as well as from our host institutions. So that's really kind of our target issue areas. We also look to, as we're doing today, kind of bring forward a wide range of industry experts to be able to walk through specific topics that may be beneficial to you as you're building and growing out your business. Today, this topic is contracts and risk management. So this is one of a wide variety of sessions both our center offers as well as our colleagues throughout the state. So I'll put a link in the chat for you also to take a look at some of our other upcoming sessions. Our center specifically is offering some sessions coming up on online sales strategies, government procurement opportunities, and we have some other sessions percolating as well. I think on business valuation, I think is one of the one I wanted to make sure I mentioned. So I'll put a list in the chat with all of the variety of sessions. And feel free to register for one or many, and hope to have you join us for those. And lastly, the last thing I'll put in, I made brief mention to resources that are available for businesses who are looking to get themselves either back on track and or take advantage of opportunities that are out there with respect to the COVID-19 recovery programs. I will put a link in the chat that provides information about the varying public and private sector programs. As you may know, a number of the city, state, and federal programs have expired, but there are a number that are still available. And then there are also from varying, private sector foundations and other sources, new ones do arise. So we've been keeping track of those and making sure our clients are aware of them and taking advantage where possible. So that's kind of a very brief and quick description of kind of who we are, what we do. Again, look forward to working with those of you who are not yet, and for our existing clients who are on today. Great to have you joining us for the session, which will be offered and led by my colleague, Jessica Magaldi. He's the Ivan Fox Professor and Scholar of Business Law, and a colleague of mine at Pace University's Lubin School of Business here in Lower Manhattan. Jessica's really has provided some great insights to our clients, both through webinars and through other content, and I'm delighted to have her back to lead this session. So, Jessica, it's all yours.
Thanks, Andrew. Thanks, Renee. Thanks for having me. I'm really excited to talk to you guys today because one of the things I like about my job is the ability to demystify things for people. We fear what we don't understand, and the easiest way to do that is to try and get some insight into into the things that we don't know about. So a tiny bit about me. For 25 plus years, I've been a deal lawyer. I work across industries to put deals together for my clients. I've worked for service providers, and I've worked for clients who are procuring services from them. So I've got both sides of that relationship. I started in the industry, putting together like 10-year multi-billion-dollar relationships for Fortune 500, Fortune 100 companies. And the biggest thing I noticed about that is that nobody ever knew what was in their contracts. We would take 5, 6, 10 months to negotiate a contract, and then someone would put it in a drawer and never think about it again until there were problems. So what I'm hoping to do today is kind of talk about some of the issues that we want to think about from a business perspective, and then think about what the sort of legal side of those, how we can address that, how we can mitigate those potential risks. And I'm a small business owner myself. I run a business and legal consulting practice. So I also understand where we're coming from, from that perspective. And I've been a teacher at Pace for almost 20 years. And that's, I guess, what's brought me here today. So on the next slide, I just put together a little sort of session objectives, our agenda for today. Right. So, my hope is that we understand that sort of context of contracts, the big picture stuff, identify some legal issues so that you can kind of figure out, either enough to make some decisions on your own or enough to figure out when you need to call a lawyer. And then, appreciate the significance of, kind of those, the big issues that come up all the time, that sort of key legal terms. So, I've got a client. Most of my clients are emerging technology companies, companies who have sort of grown beyond the point at which they're using like their neighbor to do their legal work, and they want to sort of professionalize their processes. So one of the things I help with is contracts. I help with employment, all of those things, kind of to get you to that next level of being out there in the world. So one of my clients that I'm thinking of, the HR rep there is so afraid of any legal terminology. She'll send out a document to a prospective consultant that she might work with, and she'll come back to me and said, like, he changed a few things. Can you take a look at it? So, I mean, it's great for my hourly billing rate, but what I would really love is for her name's Amy, for Amy to be able to get in the position of like, okay, I've taken a quick look at what this person has sent back, and I see like I don't need a lawyer for this. I can make those changes to the document and we'll be good. Okay, this is beyond the scope. Let me talk to Jessica about what she thinks. So part of this is about confidence, right? It's about sort of knowing what you know and what you don't know, and hopefully that's that's one of our goals for today. So on our next slide, I speak to that, right? I want you to be comfortable and conversant with the general context, with the language, with the issues, right? I know you're not a lawyer. Most people in business do not want to be lawyers. Many in, especially, creative professions couldn't think of anything that's more, more horrible. But, again, if you can arm yourself with, just what you need to know, in the law, we call it issue spotting. You can spot that issue, figure out, okay, now here's what I think I'm going to do. So, again, as I say, the most important on the next slide, like the most important takeaway is when to call the lawyers, right? If you learn nothing else from this webinar, you learn like what you know and what you don't know, or what you don't even need to know, where you just want someone else to handle for you. So now if we go to the next slide, we'll sort of get to the nitty-gritty of where we're where we're coming from, right? So what's a contract? A contract is a private arrangement between usually two, but two or more parties, and it defines the legal rights and responsibilities of the relationship. So I put a few contracts up, just like the front of these contracts up here on this little pic. But when I look at these contracts, they represent 51 pages of documents. At its most basic, what we're trying to do is come to some, mutual understanding that there's this between the two parties, and then we're trying to write those down, so that we have proof later that this is what we agreed, so that we can, have that transparency. But the more you the more you put in, the more complex it gets, and the harder it is to keep track of exactly what was it that we agreed on. So let's move to the next slide. The easiest way to think about all of those things that are in the contract is that there's rights and responsibilities. So every single right that you have in a contract, so you may have the right to get paid. You will have a responsibility associated with that. Perhaps you're going to provide a service or provide goods at a certain day and time in order that you get paid. So those two things, we want to link those in the contract, right? You'll get paid once you provide the services, or you'll get paid and then you'll provide the services, whatever we decide, whatever the parties decide the right relationship is. And then, if you're going to get paid, then the other side of that is the responsibility of someone to pay you, that person on the other side. And if you have the responsibility to provide those goods or those services, then that gives a right to the other party to be able to expect that they're going to get those goods, they're going to get those services of a certain quality, of a certain, on a certain time or a date, or that meet a certain expectation. And I put a little picture of Spider-Man, up here, with great power comes great responsibility. But that's, it's a good contract that has, both of those things, right? I've got the power to demand that things happen in the way that we set them out in that contract, but I also have the responsibility to uphold my obligations so that, those things can happen. It's on the next slide. I've got, I put a little arrow, set of arrows here, right? So the most powerful notion of a contract is that it's purely a private interaction. We don't need to file anything anywhere. You don't need to get permission from any government entity. You don't need a court. You don't need anything like that. Two parties sit down, and what we're hoping is that they create a meeting of the minds, right? That they have some mutual understanding, that they share an understanding of the various rights and responsibilities that I described. But, right, and so then you don't need to do anything beyond that, right? You sign it to indicate that you both agree, and then you've got those words on the page. But the power of a contract is that you've got the full force of law behind you, right? So you've got a responsibility to make payment, and then therefore a right to have services provided to you. But if you meet your responsibilities and those rights don't flow to you, right? You don't get the rights that you described. You've got the full force of law at your back there. So you can bring the parties to court with that contract, and you can enforce the agreement. So what that means is, after a court, after the whatever experience you're having at the court, a trial, something like that, you can you take that lawsuit, right, go to trial, you win that lawsuit, you can garnish wages, you can seize assets, you can have a judgment that stays on the books until it's paid. That's, for example, if a party doesn't pay. And if another party doesn't perform, you can sue for damages for the breach of their obligations. You can, in some cases, sue to require them to perform, but in any case, to make you whole for that circumstance. So on the next slide, I talk about this idea of what we're doing here and what it means to sort of make someone whole, right? So what we want is the benefit of the bargain. What we want is to look into the future and say, we agreed that I was going to get X number of widgets at Y price on day Z. right? And I didn't get that. And that widget was a component for a larger device that I was creating and going to bring to market. And so if we were to say like, well, those widgets, that component part didn't come on time, and what we'll do is we'll just give you your money back, right? And then you'll go your way and I'll go my way. That's a unraveling of the contract, and that takes you back in time to where you started, right? Where we started was, before we negotiated this, I had no relationship with you and I had no expectation that you were going to perform. But what we want with a contract is forward looking. We want to look to the future and say, what should have happened? What I want is compensation for the fact that I had orders for my larger device, of which your widget was one component. And when you didn't provide that widget to me on time, I couldn't bring my device to market on time. And I have customers that that I now have disappointed, and I have contracts that maybe I can't fulfill. So what I want to do is I want to look forward, and I want to say, okay, the damages that I am entitled to are the damages that you see on these little steps that I've drawn here, that would put me in the position that I would have been in had the contract been performed as agreed. So I don't want to go back in time to, what the law calls the status quo ante, the time before you and I met and we thought about, doing business together. I want to look forward in time to get what it was that you promised me, you didn't promise it to me out of the goodness of your heart. There were those responsibilities that I had to meet as well. So, we created a relationship. So you see this, lots of times with like a service provider, that doesn't show, or with, as I said, component parts, from a subcontractor that you need to incorporate in other things. You might be in the position of, thinking about this if you're a service provider in your small business, so you'll want to be thinking about, the likelihood that you can meet your obligations, because if you can't, then your client, your customer is going to be entitled to these sorts of damages. So on the next slide, I talk about how, nobody wants to sue ever. Right? Least of all a lawyer, right? Because, think about the cost of litigation. A lawyer could run you $500 an hour, minimum. A litigation could take you weeks. You could be in trial for a good couple of days, and all the pretrial things that would happen before that. You're losing time from your business. You're, paying that money out of pocket, and you've got the sort of mental and emotional benefit, energy that you are spending. The U.S., we've got a reputation for being litigious. You hear like, no one wants to rent an apartment to a lawyer because, they'll sue you on any little thing, right? But as I said, lawyers know all too well, who wants to go into a protracted experience. I've got clients. I've got one particular client. They do about 10 million revenue a year. They have a client who didn't, pay their bills, and we sat down and we looked at it. They were owed about $80,000. But you think about it and you think like, if you're going to pay a lawyer $500 an hour to try and recover that, if you're going to take a couple of depositions where you'd have to sit the principals from the business down, or key employees from the business down and say like, this is the work that we did. Even before you do kind of a deposition or anything like that, if you just to go back, I mean, we've all had this experience, like just to go back through your emails to figure out who said what and when, and what the relationship was supposed to be, and where did it kind of go wrong, could take you hours of productive time. So what you're looking for is, writing a good contract that avoids a lawsuit by clearly defining its expectations. So when I looked at that situation with my client who had, $80,000 in unpaid invoices. They had worked, it was just before I came on board with them. They had worked without a clear contract. There was some dispute as to, the timing of how they did their, what they did and how they did it, and they weren't as clear cut with they're these nice guys who kind of do a lot of things, like throwing a lot of things for free, and oh sure, we'll just take care of that, it's no problem, but they didn't hold those to some, they didn't make that part of a contractual relationship where there was a responsibility on the other side to do anything. And so when we looked at it, we said, it might take you $20,000 to recover the $80,000, and who knows what happens in a trial. These guys will start to say, maybe rightly so, what, this was a little later than we thought, or this didn't come in exactly the way we thought, because they didn't have that clear sense of exactly what was going to happen on exactly what day in the way they were going to do it. And I said, what if you get $40,000, but you spent $20,000 to get it, and then you had your two principals out of commission for 5 days? Go out and just get some more business, and and leave this on the table. And so that's kind of the potential. I think had they had a clearer contract, and had they kept referring to that contract as they were engaging with their client over time, they would have had a clearer picture that they could have brought to court should they get there. And of course, the whole point about going to court is just the idea that you could, right? So maybe we don't even get to court, but the other side looks at it and says, oh, we should have done this, we should have done that, we didn't fulfill our responsibilities the way we should have. A court's probably going to find that we should pay, we'll just settle this. But because they had sort of an ambiguous relationship without the clarity of a well-written contract, they couldn't have that, they didn't have that security that they would feel, that they would, would have a greater likelihood to win the case, or to get all the money or most of the money. And so they had to let it go. So hopefully what we do in this situation is figure out like what makes a good contract, and what are the things you should be thinking about, and keep you out of that situation. So on the next slide, I talk a little bit about what does, what makes a good contract. The idea of a contract at its most basic level is that it needs to manifest an intent to be bound, right? It's got to be some written, or it certainly can be verbal, but best practice is to write down and sign so that everybody understands that this is the meeting of the minds that we had. And it's got to be based on an objective standard, so that anybody who looked at it would conclude that this is, oh yes, I understand, they're supposed to provide X, Y, and Z, and they're supposed to do it on day A, B, and C, so that a reasonable person who isn't one of the parties that are involved, right? It's not you or the person on the other side of you, so that they can conclude. There's, if you go to the next slide, there's a great, this is a picture of a bar napkin that was used to when an agent signed a soccer wunderkind, Lionel Messi. It was written on a bar napkin. The father signed the contract because the kid was 12. Age of contracts, age of consent for contracts is a whole other thing, but I assume it's not relevant in the situations that you'll find yourselves in. You'll be, working with all adults. But the court found that this, bar napkin was binding because it met the standard, that I described in that other slide. It manifested an intent to be bound. It's got the information about who's going to do what. The agent was going to represent the soccer star, and this is what we're going to do. So this is a key point. There are no formalities that are required, right? It doesn't have to be on 8.5 by 11 paper. It doesn't have to be typed. Back in the day, you used to use a wax seal, right? Or create a mark for your name. All those requirements have gone away. The only thing that you need to do is manifest an intent to be bound. And so that's why we're looking for clarity. We're looking for we're looking for, some way to say a mutual understanding. There's this great case where it's called the Zimmer case, where I think it's Lucy versus Zimmer, where the Zimmers are a couple and they own a farm, and they're sitting in a bar and they meet Mr. Lucy, and they're chatting about selling the farm. And on a bar napkin, they write, we're going to sell the Zimmer farm to, I've forgotten his first name, Mr. Lucy, for $50,000. And they both sign it. And I don't know I don't know the circumstances of how these things came to be, but usually what happens is, someone now realizes, well, that's a bad idea. Maybe between the time that they've created this agreement, they've manifested this intent to be bound on their bar napkin, and the time at which, comes to, vacate the farm, someone comes by and says, I'll give you $100,000 for the farm. What are you doing selling it to Lucy? So, I don't know what the particulars are, but at some point, the Zimmers decide, no, we're not doing this, right? And so there's a lawsuit, right, for the sale of the farm. We've got a contract, and the Zimmers are in Lucy's mind reneging on the contract, right? They're failing to fulfill their responsibilities. Lucy's there. Here's my $50,000. I'm ready to buy the farm, so let's sell it to me. And the Zimmers made a number of arguments as to why the contract didn't manifest their intent to be bound. But one of the funniest ones, and I didn't mean that to be a pun, but it's going to be a pun, was that they said that it was a joke, right? Oh, we weren't serious. This was a joke, right? And I tell my students, it's really funny. Like, well, I mean, the first rule of a joke is that it should be funny. Like, what's funny about that? And the evidence that they, the information that came out of trial was that these guys had sat in this bar for 40 minutes. They had written something first, and then they had some negotiations about it, and then they changed some of the terms, right? So I don't know if it was sell it for 40,000 or deliver it, in 2 months, and they changed it to 50,000 or deliver it in 1 month, whatever the circumstances were. They had a 40-minute conversation about whether they should, what the terms would be, and then they memorialized those terms in a bar napkin, right? And so, from the court's point of view, like, there's nothing that, if you recall from the previous slide, there's nothing that an objective, reasonable person would be able to conclude that that was a joke, right? Based on what's on that, based on what's on that bar napkin, right? So we've got a bar napkin here, for the agent and the soccer star. We've got a bar napkin there to to represent, the sale of a farm, right? Doesn't matter what it's written on. Only matters is, would an objective, reasonable person looking at this document say that it was, that it manifested on that paper an intent for the parties to be bound? And, in both cases, the courts concluded yes. So for your purposes, if you're not doing as much business in bars, right, you're going to be thinking about your emails that you send, your texts that you send, right? Like, how are you, how are you manifesting, sure, I'll deliver that to you on that day. Great, perfect, lovely, super, and then, like, is that a contract? So let's hit the next slide, and we will talk, we'll talk about all those things, right? An email, can suffice, a phone call might suffice, even a text, so some clients of mine where they have people who are negotiating back and forth quite a bit, but then they expect that they're going to memorialize something in a contract. Some of them put a little disclaimer, no matter what's in the email, no offer is made, until something's reduced to writing and signed by vice president or above, or something like that. Right now, it's not necessarily relevant in a in a small in your small business. You might not have that level of that many levels of officers, but you might say unless Jim signs the document, there's no contract here. We're just talking and working out terms. And when I say sure or super, I mean sounds good to me, and I'll get back to you on the rest. So so if we flip to the next slide, one of the things that we want to do is kind of save us, from ourselves, right? So maybe you wouldn't necessarily expect that that you are forming a contract just by email. But there is a much more significant worry that you might modify a contract by email. So, the contract says the goods need to be delivered on Friday. And on Thursday, I call you up and say, listen, I'm not going to be able to make Friday. Is Monday okay? And you say yes. Right. So what you've just done is you've waived my performance. Right. You have an obligation. An obligation in the contract that I have an obligation in the contract. So you have the right to have that obligation fulfilled. And when I said to you, like, hey, is that okay? We can interpret that as saying, sure, I'm okay with it, and I'm not going to do anything further. So one of the things that you might do is we call it a reservation of rights. You can say, like, I hear what you're saying, and I want it tomorrow. But if Monday is what you have to do, then I'm going to reserve my rights. If I have any damages from having to wait the weekend, then I'll be back in touch. But otherwise, but I acknowledge that you will perform late is different from I'm okay with the fact that you've said you're going to perform late. So one of the things we can do in a contract is we can put in there and say, like, no approvals, no sign-offs, no emails count unless it comes from the principal of the firm, the vice president, or above of the firm. So we're trying to sort of save ourselves, from ourselves by putting those safeguards into those relationships. So, little old me can't, who's the person who's going to receive the shipment can't modify the contract by saying, like, okay, it'll come Monday, just because I'm a nice person. On the next slide, I want you to really think about the concept of, we can do things verbally or we can do things in writing. And when I was preparing this slide deck, I had a friend of my kids, the mom of their friend said, hey, did you ever return that book that you lent me? And this is a copy of the book, Dory Phantasmagoria, if you've got first graders, second graders. It's a terrific book. So by a Brooklyn author. So, and as I sit here in Brooklyn, I'm happy to tell you that. So, so I said to her, I'm absolutely sure that I returned that book, but I'm just going to turn over every place just to be sure. But I have this memory of it, right? Because didn't this happen and didn't that happen? And literally, I sent the text off, and then I sat back down at my computer and I caught sight of a little basket under my desk, and I thought, oh, that's where the book is for sure, right? We are sure that we are, that we have memories of things exactly the way they happened. But, our memories are not good. Mine certainly in that case wasn't. The other side is, credibility. I might look, if you don't have a written contract, what you've got is, my word against you, against your word. And I might be absolutely, incredibly truthful, but, in my mind, but I'm remembering it wrong, but I'm absolutely certain of it. The other thing is I might be 100% right, but I am nervous on the witness stand, or I'm prone to sweating, or I have some some debilitating shyness, or even just like in a circumstances of authority, I get anxious, and I might look guilty, right? Because a lot of the times the ways that we think, that look at how shifty she looks, that doesn't seem true, so I might well be, the best person, and have the best intentions, but I might not be believable, or I might not be credible in that circumstance. So you want to be memorializing your agreements in writing. That said, if you flip to the next slide, I've got these are some of the big things that I have found people have issues with when they don't memorialize something in writing, right? There'll be some, to my last point, lack of clarity about what our obligations are. Who was supposed to sign off on that? When was I supposed to pay? When was this thing due to be, delivered to you? And then more on the purely legal side, one of the great things that we do with contracts is we limit our exposure. So we mitigate our risk by saying, if something goes wrong here, our damages are going to be limited to a certain amount. And I'm going to talk more about these things, as we move on. But if you don't write those things down and you don't explain, like, there won't be consequential damages if this happens, if your insurance doesn't cover it, you may have significant exposure, and it's not always that great if your insurance does cover it. And some of the things that matter to my technology clients, and certainly that matter to anyone who's a creator of anything, you want clarity around who owns what. You create something for a client, you want to be the person that owns that, unless you've priced that accordingly. And we'll spend some time, talking about that. So these are some of the sort of pitfalls of not having that manifestation of your intent in a written document. On the next slide, though, I acknowledge that you're going to be moving quickly, and you do not want the lawyers to slow you down. So while I know you're not going to be unsophisticated enough or careless enough to work without a signed contract, what about a quickie contract that you just need just to get started, so that we can start tomorrow? One of the things that you ought to do is have some, when you get to that point, have some form contracts available so that you can just immediately, oh yes, we can work tomorrow, here's our standard contract. But if you don't have that, or if you've got some custom relationship, you can, these things on screen are the letter of intent, letter agreement, memorandum of understanding. These are the kind of quickie documents that you could put together. And so on the next slide, I talk about, like, well, what's the benefit of that, right? So you might give up some certainty, right? If you had a 10-page contract versus 2-page contract or a 1-page contract, you'd give up some certainty on certain other things, but speed might be more important to you. To use something like this is truly a business decision, and working with a lawyer in a way that makes sense to you, you need to always be thinking, you want them to give you advice, and then you want to take that advice and filter it through your own sense of where your business is and what your business priorities are. It may be important to you to prioritize speed over certainty. It may be important to you that, or you might be comfortable acknowledging, like, yes, there's more risk in a shorter contract, but I want to take that risk for this circumstance. Or you might believe, what, I hear what you're saying, counsel, but I don't think it's as risky as that given the circumstances. And on the next slide, I give you a few examples of the types of things that are your decision and your business decision. And before I run through this, I'll just say that I was talking to my mom a few months ago, and she said to me, my mom is a big advice giver, and whether you want it or not. And so she said to me, my children, they never listen to my advice. How can this be? And I said to her, I actually do listen to your advice. I took that advice in. I thought about it with a bunch of other things that I had been thinking about. I took advice in from other places. I did some research on my own, and then I came up with a decision on my own. And I said, what, if it makes you feel better, this happens to me all the time. I give clients legal advice, but then what I'm in a healthier place on it. I'm saying this as a joke. My mom wasn't, too bent out of shape about this, but I'm in a healthier place about it than my mother, because what I was saying is, I expect them not necessarily to take my advice to the letter, right? You don't have to do exactly what I tell you. You have to take your lawyer's advice, and then take the advice of other people, and then take your understanding of the market or the relationship or the industry that you're in, and then figure out what you need to do. So, for example, someone might offer you a fee that is so high, that all considerations pale in comparison, right? If I can make 5 times my regular fee, I'll take a little extra risk on having a less formal document and not being clear on, some of the, every little I dotted and every little T crossed, right? Maybe these guys are, you know, what I'm calling the tip of the spear, right? Maybe you can get into a new industry, right? If you can get this client, it'll open up some doors for you. Or maybe this is a new type of work that you're doing that you're adding on, and you're, you know, and this will be a new, you know, revenue line for you. Maybe there's, you know, maybe it's a famous or an influential client, you know, a well-known or highly visible, you know, location, right? If you're an architect and someone gives you the opportunity to do some marquee, you know, building, you might take that and accept some of those other risks because you're thinking for the career, for the development of your business, that it's a good thing. So I guess what I'm telling you, you know, on the next slide is, you know, you're in control here. Push back on your lawyers, you know, don't let your lawyers, you know, don't let your lawyers push you around. But, you know, but be open to the advice that they're offering you, you know, and consider those things. What I found, I was a lawyer for the dot-com industry in the, you know, the boom and bust of the late 90s, early 2000s. And, you know, what you saw there was people running full speed ahead, you know, business people running full speed ahead, ignoring their lawyers, you know, all the time. So sort of the opposite, you know, the opposite problem. I'm assuming that you're, you know, that you're going to take in that advice, and that you're going to be in a position where you, you know, where you find the right set of circumstances for you. So on the next slide, I just gave a quick little, you know, I won't spend too much time on this, but you know, it's your job on the business or the creative side, right, to have those conversations with the client, right, and then to let the lawyers come in and, you know, think about what the you know, risk mitigation strategies might be, right, and then to come out of it, you know, in my like those yield some clearly defined expectations. That's all your contract is meant to be: clearly defined expectations, business, creative, legal, you know, whatever those things are. So familiarity, on the next slide, I've got, you know, so let me start you in on some of the things I said that will kind of give flesh to these, you know, put flesh on the bones of these things. So familiarity with legal terms, right? And if we flip right to the next one, there are kind of three main categories of, you know, legal issues and contracts that you should be thinking about. It's limiting your liability. It's matching yourself up with subcontractors and what they're you know, what they're willing to give you and what you're willing to give the client, and, you know, how to align with insurance. On the dispute side, it's when you can bring claims and how you want to bring those claims: mediation, arbitration, litigation, and how you terminate your relationship if you need to. On the ownership side, it's ownership of your ownership of what you create, what your customer might get to use, and how you might align that with getting paid. So on the liability side, on the next slide, actually I just give you the we'll go from this slide right to the next one as well. You know, so here's an example of a, you know, liability provision. You don't need to read everything here, but when I look at this line, this requires claims that need to be brought in 10 years. That's called a statute of limitations. It limits liability to what's covered by property insurance, right? And it waives consequential damages for claims. So these are sort of the three types of things that you know, that I talked about over here. So so if you flip to the next slide, this one here is the limitation of liability. So one of the things that you might do is, if you've got insurance and your insurance will cover you in certain circumstances, then what you want to do is say to your client, I will be liable to you in these circumstances. Anything beyond that, and then I won't, right? And so then you'll pass through your liability to your insurance company, and your out of pocket will be, you know, except for whatever insurance provisions you've got, will be, you know, will be zero. If we flip to the next slide, we've got one of the most important things that you could do is put a liability cap. So that one was aligning it, the previous one was aligning it to insurance, but this one is limiting for what might be happening and how you might be going about doing it, right? So I can limit my exposure if my contract, if the relationship that you and I have is worth $10,000 to me, $100,000, $1 million, I can say that my liability will be limited by 10 to 10,000, 100,000, $1 million, right? That whatever goes wrong, even if it's my fault, I won't be liable for more than the value of the contract. We can pick a different number, twice the value of the contract, half the value of the contract. We figure that out between us, and you see what feels right to you. But you want some limit, otherwise it could be anything, right? So if you do a quickie contract or a contract without any provision on liability, then you will be exposed for anything. So you are a technology provider and you're going to migrate someone's email, and you lose a bunch of emails in that migration, and you were going to get $10,000 for doing that work, and they can prove that the emails that were lost cost the company $2 million, right? That would not have been a very good deal for you to do, right? That that one slip up can result in liability for you. I don't remember I can't do the math quickly enough, but so many times higher than what that relationship even cost you. So one of the things that the courts will never let you allow, New York law won't let you allow, and most state laws are the same. They won't let you limit your liability for gross negligence or intentional bad acts, right? So I can't go in and destroy your emails and then say, oh, I'm only responsible to the limit of $10,000. But I can limit for any of my own negligence, right? So I can perform poorly, which happens, and as long as it was negligent, as long as it wasn't intentional or grossly negligent or reckless, I'll be off the hook for that. As I said, you can limit to a dollar figure. Some people also do formulas. Some people, you can, and as I said, we can limit to the amount paid by insurance. So on the next slide, consequential damages are one of the most important things that we can limit our liability for, right? That's the sort of domino effect of, all of these things. There's a great case where a contractor hires, a homeowner hires someone to roof her house, and the contractor doesn't show up in May. And she doesn't hire another contractor, and then in the fall, which is the rainy season, wherever this was located, her roof leaks, and she loses hundreds of thousands of dollars worth of stuff, new floors, new walls, the whole thing. And so she comes back and says to the contractor, you're responsible for this. Well, the contractor's responsible for not having shown up. The contractor's responsible for if she needed to hire somebody else, and that person was twice the price by the time she went off to find someone on short notice. But the contractor's not responsible for consequential damages, because there wasn't something that went wrong with the roof. It was not having the roof 4 months later that caused the rain to come in. It's too many intervening events that could have been there. So most times the law doesn't provide that kind of liability anyway, but the best written contract will always have a consequential damages clause limitation. If you look at any cell phone contract that you have, your Wi-Fi contract, they'll all be consequential damages, right? If you miss an important call because your cell phone didn't, the call didn't go through on your cell phone, Verizon's not responsible for the fact that you lost out on a important client opportunity. That's a consequential damage. So on the next slide, just a quick note about subcontractors, right? If you work with others, and lots of small businesses, collaborate and pair up, and you want to think about liability caps, because if you contract some portion of the ultimate responsibility to a client, if you contract a portion of that to a subcontractor, what you want to make sure is that subcontractor is not going to limit their liability to you, right? So the subcontractor limits liability to $10,000. So if something goes wrong between you and the sub, you can only get $10,000, but you didn't also limit that liability to the client in the same way. So you're on the hook to the client for $1 million, and that delta is, is bad news for you. You want to align your liability provisions so that whatever you've promised to the client, you can also get, from your subcontractor. The other thing you might want to do is seek indemnities. That's a provision that says that the other party will be responsible. End of story. So on the next slide, I discuss, so client sues you for an issue with the subcontractor. You're responsible to the client, but the subcontractor is responsible to you. And so you protect yourself from liability that way, where you say that, whatever happens in that relationship with you and the client, then the subcontractor steps in and is responsible to you in that circumstance. So the next topic is disputes and termination. This is about your time to bring claims, how you want to go forward with those claims, and then what rights you have on termination. So on the next slide, I talk about what's called the statute of limitations. The default rule on a statute of limitations is 6 years. So if your contract says nothing else, then you have 6 years to sue the other party for something that went wrong. The beauty of a statute of limitations is it gives you some peace of mind. You know that you're no longer liable for anything related to that contract. This is important for you if you get purchased, right? Your purchase price will potentially be, this will impact your purchase price because someone who looks at your contracts will say, oh, there's a lot of value here, but we don't know what litigation risks might come to us, and so we're going to have to build that in to our price. And even if you're not being purchased, right, what you want is some peace of mind that the client will never come back to you, after a certain point. So whatever reasonable period of time that is, 1 year, 2 years, X days, weeks, months after the deliverable has been delivered, right? Whatever you agree on by the parties, you can contract out of that default rule of 6 years and shorten that time period so that you've got that peace of mind. On the next slide, I talk about kind of how you're going to go about taking disputes forward. I don't want to inundate you with slides of tiny writing, from a contract, but parties usually have, some steps around go to mediation first, and then, then you'd have to either arbitrate or litigate. And people never think too hard about these things, but you want to think about, how is it that you, choose one over the other. If it's important to you to move things through quickly, right, you might want to try arbitration. If you're in an industry where you think people won't really understand how a judge wouldn't necessarily understand how your industry works, you might choose arbitration. Otherwise, you might be, comfortable being able to, sue someone and take them to court. The auto industry uses arbitration around, when two cars are in an accident and they each have insurance, right? They use arbitration just to, to decide who's at fault, so that they can decide, which party pays that deductible and or whether, one party is paying the claim of the other. And they usually use a third insurance company. So that's not involved in one of those things. And they, they can flip through these things so quickly, much more quickly than a court could, because they're, used to all the terminology and all of the information, and you certainly don't need a jury or a judge to weigh in on something like that. Arbitration's often your best bet because you're well served by someone sort of familiar with the industry. you'll also want to think about if you're a customer-facing organization, a jury is much more likely to, actually, if you flip to the next slide, thanks. A jury is much more likely to side with another customer because that's who they can relate to. You know, again, if all things are equal and we're just going on the emotion of juries, right? I actually have a lot of trust in the jury process and in, you know, jurors being able to dispassionately look at the evidence and make decisions. There's been some really interesting cases that have come down recently, you know, where you think, oh, the jury's really given a thoughtful verdict on that. But you know, I'm more likely as a juror to identify with the problems of, you know, of a customer than with a cable provider, you know, a Wi-Fi provider, or, you know, something like that. So, you know, you want to think like, if you're not going to be so well served by that, maybe just agree that you're going to go to arbitration between the parties. Ownership is the next slide, and it's, you know, something that's often, you know, that nowadays people are very sophisticated in thinking about their ownership, you know, as they go in, right? We're gone are the days where people, you know, are being kind of snookered, you know, by others on this. But you've got to be, but even if you come in with the best of intentions, you have to make sure that you, you know, that you are clear with your client or customer about it, right? So you want copyright ownership in most cases, or patent ownership to remain with you, and you want to give your customer a license to use that work, and you want to give them a full license so that they can, you know, get their money's worth and get good use of it. But you don't want that license to be granted until they've made full payment. I've given on the next page just a slide of some, you know, some, and if you flip one more slide too, I've boxed up the relevant language here, right? So this is from an architect's, you know, an architecture contract, right? So you know, in this case, they want to own all their drawings and all their specifications so that they can use them from one client to another. That's the most important. You know, come back to someone who says, but I paid for it and I want to own it, right? Well, what you paid for is my expertise applying the things that I created to your particular situation. And my price would be 10 times higher, you know, if I needed to start from scratch and couldn't use anything that I'd ever used for someone else. Because what I do is I give my clients the opportunity to use these things, but I keep ownership of it. And while I'm not, if you flip, you know, one more slide, just to, I moved my little box down there, right? So what I'm giving you is this non-exclusive license to use what I provided to you for the purpose of, you know, what we've described. In this case, it's to, you know, build the house or the building. So you've got everything you need, but I can continue to be able to provide my service to others because you haven't closed me off. If I give you something and you own it, I can't ever use it again. But if I give you a broad license, then I can slice and dice whatever that thing is and use it elsewhere. So this is an architectural context. You also see this in software. You see this tremendously in software, right? I'm building custom software for you, and it's going to be particular to the way that you know, need the app to work or what have you. But I'm using the back end of that, you know, or some of these other components of that are going to be things that I've created, and now I've mixed and matched them for you in a particular way. So I can't have you own the payment mechanism, right? Because I've already used it with others, and I'm going to use it with others in, you know, into the future. So, you know, they've paid for your expertise in that circumstance. So my last slide is something I've sort of already alluded to at the beginning, so I want to come back around to that, right, is, you know, how you can deal with your lawyers, right? It's, you know, your lawyers are going to be busy. You know, they're going to be juggling a lot of priorities, especially if you're a small business. You know, you might not be the biggest fish they've got to fry. And so, you know, and often everything that comes to them, you know, is some kind of emergency. So you're going to want to try and give them as much lead time as you can for things that aren't emergencies. And then you're going to really, the best thing you can do is clearly communicate what you need and educate them about how your business works and the things that are your priorities. And then, as I said, like that example with my mom, you're going to consider their advice. You're going to push back as necessary, but the ultimate decision is going to be yours. So there might be, a circumstance where you're willing to give up ownership, or where you're comfortable tying, not necessarily tying ownership to full payment, as I've said, or where you're okay with unlimited liability because based on the relationship, you don't think anything's going to happen, or based on the type of work you're doing, you're not worried about the possibilities. And so, consider their advice, and then, make whatever decision makes sense for you from your business perspective. So the last slide's my contact information. If anyone wants to get in touch with me at PACE, not necessarily, or then there's my LinkedIn info. But of course, the folks at Andrew and Renee are your best bet for most everything else. Questions, thoughts, comments, and thank you.
First of all, Jessica, thank you. It was a terrific presentation as always, very insightful. And just one quick item I wanted to sort of, tease out a little bit, which is something that we certainly see with a range of our clients historically, is your comments about having some sort of agreement template or some sort of quick arrangement in place. So many of our clients, see these great opportunities, and I love kind of the categories of why folks might go forward without having something formal in place. And certainly there are a lot of good reasons, and you really identify them so effectively. I think but for the small business we work with, sort of making sure that you take to heart kind of what Jessica was describing in terms of making sure you have something kind of to hang your hat on at the end of the day. You want to, there is some risk involved, but you want to make sure that you have capacity to make sure you're getting paid for this work. So just that in particular really jumped out at me. There are certainly a lot of things in here, but one thing in particular I want to make sure I made reference to, and sort of more broadly, thanks very much. It was
Yeah, thank you. Yeah, we all, as I said, we all understand, I want to jump on this while I can, right? Because otherwise, the opportunity might go away. So how can I figure out, what my priorities are, what risk I can minimize, how I can make this work for me, right? If you don't have a lawyer who understands that, then you need a different lawyer, because I'm not meant to be a roadblock for people, right? I'm meant to help you. I'm meant to help you realize your business priorities, and just protect you as best we can.
This first one is from Willow. Thank you for all of this. Are you available to review agreements we create ourselves or to direct us to templates or sample contracts to begin with beyond, say, what's available on Rocket Lawyer and the like?
So Andrew and I are working on trying to figure out how to make some services available around those things. But I will say that Rocket Lawyer and those things, they're not terrible in terms of, they'll give you a place to start, and they'll give you a sense of, kind of what what might make sense in that industry. There's also lots of, white papers out there, lots of like quick small articles that people have written, which will tell you like, do this, don't do that. But yeah, we're going to try and figure out, I understand that legal is one of the things that we're trying to figure out how to provide that to folks.
Thank you. I appreciate it.
In a more limited capacity, I guess, in the interim, I guess I'm looking forward to figure this out with Jessica. So again, there's so much demand and need for it. In a more limited capacity, there is a program. Well, I'm not sure if you're based here in New York City, but there is a program through the City Bar's Neighborhood Entrepreneur Law Project that there are some pro bono and low-cost services available through that program, and I'll find the link and throw that as well.
Yeah, that's a good point. I know the City Bar does a referral line as well, separate from the NELP thing, but that they'll do a free consult for you at the New York City Bar Association, and then either send you to a lawyer they might be able to solve your problem right there in that half hour, or to a low-cost lawyer as well.
Absolutely. And if you if you run across any upcoming webinars that Andrew's team puts out with the City Bar, I would highly recommend you attend those. Those are always a great thing to sit in on. This one's from Ernest. If the business employment contract pertains to a special field, for example, healthcare, a hospital employment contract, what are the projected contract review and counsel fees typically?
So I don't know the healthcare industry in particular, but I would say that you've got legal fees on a $200 an hour minimum kind of basis for an established lawyer in that field. And I guess that's the short answer. What I might recommend is, if you find someone in the field that makes sense, to work out some kind of fixed fee arrangement so that it's not a per hour thing, especially if you're going to have multiple things, so that they can, they'll get to know your industry, they'll get to know your niche in the area, and then they can just continue to apply those same things. Also, what I recommend on those kind of things is ask them, spend the money to ask them to draft you a form, and then use that form as you go forward. And I, what I often do for clients is draft them a form and then a playbook, right? So if they push back on this, then you can offer that. If they push back on that, then you can offer this. So that might be a good use of, when you're trying to be careful about funds, in early days or any days. We should always be careful about funds.
Thank you. We did get a thank you for that one. Andrew, is there a clinic at Pace University?
Is there if by clinic you mean the city bar hosts things called legal clinics, where they do 45-minute sessions at no cost to folks who register. Those slots do go quickly. In the link that I sent into the chat, there are opportunities for you to kind of find out more about those programs. In terms of Pace University, we're not affiliated with the law school, where we're based out of the business school here in Lower Manhattan, but Pace's Law School does have a food and beverage clinic that if you are in either of those industries and you're interested, it's more in production, it's not restaurants, it's not bars, but if you're a distillery, if you're a food producer, there is an organization through the university's law school that is able to serve and help businesses in those fields. So I will find the link for that and throw that in the chat.
We did get a request to go back to the manifest and intent to be bound slide. I can jump back to that while you answer the next one, because it might take me a second, unless you remember exactly where it is, Professor.
No, it's early on, but I don't know exactly.
Okay, I'll jump back to that while you answer the next question. What's the biggest, most common issue business owners face when it comes to this area of business?
Now, I don't know enough about the specifics of what you're asking. So if what you're asking, I would say the biggest pitfall is no contract at all. The sort of next biggest pitfall is, some lack of clarity around obligations. And then particularly obligations around who owns what as you go forward. But I'm happy to, if you want to clarify, I'm happy to, laser in more carefully on what you're, on some particular area of your question, if you'd like.
No, they said that was a great answer. Thank you. And I'm asking if this is the right slide. If it's not, let me know. Okay. Is it okay to sign a contract with not your legal name, the one you have in your passport? For example, my name was Moshi, but everyone knows me by the name of Michael. Can I sign Michael? I realize we can use two names at the same time to be safe, but I'm looking to understand if it's a yes or a no.
This goes back to what you can, what you want to, where you want the clarity to come from, later. So if everybody knows you as this person and they, of this one name, and that name is on the contract, and, that name refers to you, then there should be no issue, around that, even if it's not a legal name. Now, I say this is your, if there is an issue, it's to your benefit in this case, right? Because you're the person who's using the alternate name. So So I'm less, I'm sort of less worried about that. Like if there's some problem about that, if you're my client, I'm less worried about that in that circumstance. But of course, since I'm preaching, clarity of understanding and, responsibilities between the two parties and, the sort of fairness and like having this all work out right, then I would fall back to, as long as we understand that this is who that person was meant to be, right? So that there's not an opportunity for you to go, what are you talking about? I'm not, that's not me. Like, I'm not bound by this. Then you're okay. But if you're asking me for really the full on, of course, so-and-so as such and such, right, is the, the clearest way, to be very clear about who we are and who we purport to be. But I'm certainly in the case of, of someone who's maybe transitioning or who's got a dead name, like there's lots of respect around, for, this hasn't been legally changed yet, but but we're going, but we understand that this is who this refers to, whom this refers.
So someone was having a problem clicking the links in the chat, Andrew. I did let them know they may have to copy and paste the link into their browser. So if anybody has an issue with that, try that. And if it still doesn't work, just reply to your GoToWebinar email because that will go directly to Paste and they can get you the correct link for that. I believe this is the last question, unless there is one that comes in while I speak this. What should be included in an independent contractor agreement? How long should they be contracted for?
What should be included? That's a broad question. What should be included in an independent contractor agreement depends on, are you the independent contractor or are you engaging the independent contractor? The default in the law is that whatever the independent contractor creates belongs to him, her, them, and not to the person who contracts, the entity that contracts, unless it's in writing. So so any deliverable, so you want clarity depending which side of the, you want clarity anyway, but but it'll matter differently to you depending which side of the transaction you're on, around ownership of whatever deliverables are being provided. And you'll need to say that need to say in writing that ownership is going to transfer, if it is going to transfer, or that there's just going to be a big broad license, like I alluded to in my ownership discussion. How long? As long as you need, as long as you want. One of the things, couple things about long independent contractor relationships, you may want to change the fee structure. Right? So you might get to a situation where like you create an independent contractor arrangement and then you do like a quick little statement of work associated with it that says, for 2022, is that what year it is? 2022, the fees are $150 an hour, and then we'll revisit them, in 2023. So that might be one of the issues that come out with this, with a longer term arrangement. So you can have you can also have a relationship contract that says like, we're going to work together and these are the terms that we're going to work together on, but we're going to do little projects. And whenever that project comes up, we're going to attach that to that contract as a project order or a statement of work or something like that. And so our relationship can be ongoing, but we might not have an active collaboration at any particular point. So that's kind of a way to sort of keep that evergreen. So then, pricing and deliverables and whatever will be, well, this project will take 2 months, and so we'll do that. One big thing, but maybe a small risk right now, depending what stage you are in your business, is, the more you make an independent contractor relationship look like an employment relationship, you run into potential trouble with the IRS, that you're not, that you're not treating an employee as an employee. Microsoft had a problem with this back in the 80s. They had people sitting next to one another. Some were employees, some were independent contractors. When they went public, they were like, well, all the employees have stock option, but independent contractors, right, you don't get stock options. And those guys successfully mounted, it's a seminal case, successfully mounted a lawsuit that said, like, you treated us just like employees. We came and went, we ate in the same cafeteria, we did all the same work. And so there's no good reason for you to describe us as independent contractors. We'd like our stock, please. and they won that case. So if you're you can certainly opportunity to have long-term relationships with independent contractors, but what makes an independent contractor different from an employee is that independent contractors define their work arrangements. Usually you're buying, you're paying for a deliverable, not for a 9 to 5, or whatever your hours are, so it's sort of time, place, manner, the contractor determines how they work. It's sort of a perfect segue into the fact that, Andrew and I are building out an employment webinar to happen in spring of this year, where we'll discuss, employment issues and independent contractor issues in much greater detail, at the level of detail of this presentation on contracts. Disney, Amazon, Walmart, there are a few players like where these are the terms, and they are not willing to negotiate. So they're the perfect, maybe I'll work that into my presentation. I mean, they're the perfect example of the things that I was talking about, where you might say like, okay, I've got to forego, some of the things that I might want in favor of being able to, to work under these, work with this, with this company. So yes, the playing field's not level, and specifically, I don't know Walmart, but I do know Amazon and Disney. I don't know Walmart in particular, but often, they say this is our contract, we don't negotiate it, and take it or leave it. And I would say, the thing that you're looking for there is reputation. Then, okay, so how are they to work for? How do other people think? Do they sue at a drop of a hat? Do they uphold their obligations in ways that people are comfortable? And so you have to sort of get comfortable on the sort of extra legal, on the business side of things, in order to take that opportunity.
On the business side of things, that's more kind of our advisors kind of focus, I think, in terms of this specific relationship describing, thinking about things like, speed of payment. Do you have the capacity to lay out for materials for staff and for other things in advance of kind of receiving that payment? Very much like if you're working for, let's say, a government agency where, delivery of service and payment, there could be kind of a big gap there. So making sure you have sufficient working capital in place. And then two, on a pricing side of things, our advisors spend a lot of time looking at, whether you have the capacity to, or at least the understanding to make sure that are you, selling at a price that's going to be profitable for you. So, are you going to get yourselves in a position where you're, doing gangbuster business with a place like Walmart, but if you're doing it at a loss for every unit, you're going to quickly run yourself out of business. So making sure that as appealing as an offer like this may look, make sure that from a business perspective that it's something that's going to help sustain your business and not run you out. Jessica, thanks so much for the session. It was really great content, I think really insightful. Thank you both very much.